Welcome back, ladies and gentlemen. You're watching India Tonight with me, Sumita Karira. Top story this evening. Well, Elon Musk's social media platform X is taking the Indian government to court. It's accused it of imposing an unlawful blocking regime through backdoor censorship. In fact, the lawsuit filed in the Karnataka High Court challenges how the centre is using Section 79(3)(b) of the IT Act to force content takedowns without following proper legal processes that are outlined in Section 69A. What is X arguing? Well, it says that this method bypasses crucial safeguards, ones that require transparency, reasons for blocking, and an opportunity to challenge takedown orders. The platform also says that these actions violate the Supreme Court's ruling in the Shreya Singhal case, and they pose a threat to free speech. More importantly, X also claims that arbitrary blocking orders could hurt its business and damage user trust in India. But government sources indicate that the centre believes that due process is being followed and companies must follow the law of the land. Meanwhile, another Musk-related controversy is brewing, and this time it involves its AI chatbot Grok. The chatbot has integrated into X. It has shocked users with its unfiltered and abusive responses. So on one hand, you have X fighting censorship, but on the other, its AI is under fire for lacking control. So the big question we're asking on India Tonight is this a case of big tech failing to regulate or government overreach? And should AI chatbots and social media platforms accept local laws in toto? And more importantly, is this just a sign of some bigger things to come even as AI becomes more intelligent? Well, we'll be posing these and many other questions to our stellar panel of guests. So joining us this evening is Ms. N.S. Napinai. She's a senior advocate of the Supreme Court, and Ujjwal Mohan. He's a manager of public policy at the Quantum Hub. Thank you very much, Ujjwal and Ms. Napinai, for joining us here on ET. Now, let me come to you first, Ms. Napinai. Let's have a broad understanding of what the matter really is. X essentially stating that government ordered it to take down content, and that's impacting its India operations. However, 69A of the IT Act, it gives government the provisions to do so. So what's really so problematic about Section 79 of the IT Act that X has mentioned in its petition?
I think there is a basic misconception in terms of understanding the delineation between these two provisions. Pardon me if I get a little technical, but here is the lowdown on this. Now, 79 is a special provision which gives an exemption to the intermediaries against prosecution in the event of third-party content on their platforms. So you get that exemption on certain conditions, and one of the conditions is that you will also comply with due diligence and also guidelines that the central government may mandate. In the guidelines, and that's the intermediary guidelines of 2021 which we are speaking about, you have provisions which warrant or necessitate a platform to take down, and that's the distinction, Sunita. The word here is take down under 79. So the government can call upon you to take down certain content. You have multiple timelines for the takedown. 24 hours if it pertains to nudity, then you have 36 hours, 72 hours, and you also have a 15-day timeline within which if a platform does not act, then you have an appellate authority within the government setup itself.
Absolutely.
69A, however, talks about blocking of content. So it is not just rhetoric when we are speaking about two different words here. There is a separate process involved in terms of blocking of content. You have to follow that procedure before you call upon somebody to block content online. And there is a review committee which can also look at and reverse that order. A save and accept in case of emergencies. You cannot immediately call upon a platform to block content. Now that's the distinction. So when we speak about a takedown, that's where we speak about 79, and you're speaking about blocking, you're going under 69A. So the details are not the same, the process is not the same, and the outcome is not the same.
Ms. Napinai, all of these social media platforms have the safe harbor provision, so it's completely up to them.
Because if you do not take down content under 79, all that it entails is then you may be held liable for the content as the creator.
Absolutely, Ms. Napinayan, this was one issue that was brewing even during elections, during Lok Sabha elections as well. And of course, in 2023, December or November of 2023 as well, when the government gave guidelines to social media companies to follow the law of the land, because, of course, there were deep fakes that were doing the rounds. And of course, these companies, these platforms have to take accountability of third-party content on their platforms. And this law, that 79 section of the IT Act essentially talks about that. So let me ask you, Ujjwal, how does this regulation really impact freedom of speech and expression in India? And what are the safeguards that are in place to prevent the abuse?
Thanks for having me, Sumita. As Nabina ma'am also touched upon, there are two existing powers already within our Information Technology Act architecture. One is under the 2021 IT rules, and one is also under Section 69A, as you pointed out.
Yes.
Both of these powers have a certain degree of safeguards that come in respect to a review committee, a notice, etc. Now, of course, what we have to recognize is Section 79(3)(b), as it has been implemented over the past couple of years, especially over the past year, has meant that several government agencies have been given these kind of powers. And that brings me to the first point that comes out of this case, which I think is fairly important for us all to consider, which is the role and relationship between different agencies of the government when it comes to blocking content online or when it comes to online censorship. So over the past year, if I can bring to the attention of the viewers, some of the powers which is unchecked under 79(3)(b, because under this provision, there are no safeguards when it comes to it going through a committee, it going via a particular process, or having its specific purpose. So when we share these kind of powers with departments such as the railway department or the tax department, we have to recognize that there are free speech implications. Now, why do I say that? I say that because we have a central ministry in India, which is the Electronics and IT Ministry, which over the years has built up experience on when it actually issues a blocking order and when it does not. Because as you know, the gray areas with online speech are quite difficult to navigate. So when we now devolve these powers to organizations or agencies that don't typically have that experience of regulating online speech, it becomes a bit challenging because it becomes unilateral. An example of this was when we saw that there were videos of the stampede and other such situations happening in the railway station. The railway department actually wrote to X to try and curtail that kind of content from going viral. Now, while there may have been legitimate interests on the government side, it also importantly implies that free speech and free expression values get involved in that discussion. This is, in fact, the second point that I wanted to highlight, which is how we treat blocking powers in India. Now, for instance, this is not the first case that has come to the judiciary in terms of how we regulate or blocking. In fact, the Supreme Court today is also concerned and has admitted a petition that deals with how 69A powers are also exercised and implemented in India. So I
Right.
think broadly,
Right.
cutting across the legal
Right.
technicalities, the limited point I would make is, as an outcome of all of these cases, it would be good for Indian law and policy to land on a blocking procedure that is simple, that is balanced, because of course free speech issues are
Okay.
difficult to navigate, but are also transparent. So I would say that is
Okay,
where I
okay.
will.
That's a valid point, that free speech issues are very difficult to navigate, even as we are moving in an age of AI, artificial intelligence, deep fakes, etc., and which perhaps needs a new law. This is something that's been suggested by Rajiv Chandrasekhar, former MOS in IT. And let me bring that point to you, Ms. Napinai. Does India really need a new law, amendments to the IT Act with respect to these new age technologies that are coming up? And of course, there are far more challenges as well with the coming of of these technologies with respect to content.
More importantly, we need a new law because if you look at the genesis of the Information Technology Act, it did not have a focus on cyber crimes. It was meant to enable e-commerce. So it was for a very limited spectrum, right? Thereafter, you have been kind of expanding the law to fit in provisions which at that point of time seemed essential. So in a way, that was more like a band-aid syndrome. So because we did not have the right vision at the time when the IT Act was formulated, probably we need a new law. But we also need something more critical, Sunita, and that's you need better implementation of the law that you have in hand. We need to see how well the existing law is being implemented or enforced, how effective is it, and how properly is it being utilized. We are talking about the possibility of abuse, but even in terms of use, how much are we really seeing it through example?
Right, but Ms. Napina, I also have to take you through this information that I've received, which is with respect to information and removal requests. And of course, X has not fared well as far as that front is concerned, whether it's in United States, Japan, EU, UK, and some of these countries where its compliance rate or disclosure rate has fallen below 50% in some cases. So let me come to you, Dhruv, on that point. Let's speak about the timing of the move, right? Given that ministry officials are also speaking with X on, Grok's bizarre response. So how can X on one hand talk about freedom of speech, that it's being curtailed in India, whilst at the same time it has a chatbot which is freely abusing people? How does that come under freedom of speech?
Hi, can I come in on this as well?
Yes, please.
Thanks, Sumita. So I think that's a very interesting, like you said, it's a question of timing that this has come up. So I'll address your first point for, separately first, which is whether we need a new law and how that interacts with what's happening right now. I think at the outset, we need to recognize that blocking is a very limited solution. It is one of many tools that policymakers and governments must have. So at least for one reason why we need a new law is to counter new challenges, like you said, with respect to AI, etc., where blocking might not be sufficient. But addressing your question head on, right, as to what is happening really with Grok and its unfiltered responses. Well, I think whenever new technology comes up, it always tends to like overwhelm us, and we wonder whether we can grapple with this using existing tools. I would say that I think today we are not in a policy vacuum where we really need to worry about, okay, how do we deal with something like this? Because at least the elements of the answer, which is the first step in the immediate future, are already with us within the ID Act. While, of course, there is one aspect of, is this AI technology safe? Is it doing the things that we consider to be desirable? That is one
No, but
question.
Ujjwal, my point is, and let me ask that question, one final question to Ms. Napinai, because we're completely out of time. Ms. Napinai, the essential question is about why has X not intervened when its Grok is freely abusing people? Because the government has not really intervened. So why has it not taken cognizance and, removed these pieces of content and, tried to rein its AI chatbot in? Can big tech be above law? Because, these are some concerns that have been raised in multiple other countries as well. So whether it's Turkey protests, in India as well previously, and Elon Musk himself has called himself a free speech absolutist, and he stated that free speech should be absolute, but at the same time critics have stated that he is trying to push the propaganda in favor of Donald Trump. Ms. Napirai, final few words before we close this.
Very quickly, here is my take on this. All of us are concerned about free speech and we want it, but in India, it comes with reasonable restrictions. And if you are offering your services within India, you have to comply with the law of the land. Incidentally, when I got an invite for this show, I put this question to Grok, and Grok says it does not have a kill switch when it uses swear words. So this is not something that they have not foreseen. It is a very clear gap which has probably consciously been left, and that's something they will have to address. Or, as I told you, the distinction between 79 and 79 and 69A is, in 79, all that it entails when you don't comply with the notices, then you are also liable for the consequences of the content on your platform. At that stage is where you can exercise your free speech rights to show before a court or in a proceeding that whatever is said is not violative or it is an exercise of free speech, etc. But where does free speech stop? Will it extend to using swear or abusive words? Will it extend to spreading misinformation or disinformation? I think that's where the crux of the issue will lie.
I think, Sumitra, just to add to that, one quick point.
Absolutely, and absolutely not. It cannot stop at that, and which is perhaps, which is perhaps why the government really needs to look at the existing regulations, with respect to this technology that's fast developing. In fact, let me also take you as we close the show to Elon Musk's tweet in the April of 2022. He said, "By free speech, I mean that which matches the law. Therefore, going beyond the law is contrary to the will of the people," and that's something that X will have to follow. Any other platform will have to follow when it comes to following the law of the land. On that note, thank you very much, ma'am, and thank you very much, Ujjwal, for joining us and sharing your thoughts on this very, very crucial debate.